let's get right into it. Professional esports athletes, freelancers, or employees. Andreas already hinted on it. Why does this even matter? Well, simple answer, because employers who try to circumvent German employment law might face serious consequences. I've just listed you some of them. As Andreas already mentioned, most of them security law related. Taxes you saved must be paid back. And this could actually break an esports organization, because when you think about the LEC of Riot Games and League of Legends, they have a minimum wage of about 60,000 euro, up to 450,000 euros in the star player cases. So this times 5 for 2 years, no taxes. You can count that yourself. You can do the math yourself. This could actually break some esports organizations. Furthermore, criminal liability, of course, and least but surely not least, you can gain an entry in the German Central Business Register for the respective company. So these are actually quite serious consequences if you try to circumvent German employment law. Furthermore, of course, if you're an employee, then you're protected by employment law. We're talking requirements for fixed-term contracts, loan work, contract termination, paid leave. All of those things have special requirements. And this is why it's really important to answer the question. So, second question, is German law even applicable? Because, for example, esports could be a Polish player playing for a Spanish esports organization based in Berlin, Germany, trying to compete for a world's title in China. Esports is a virtual phenomenon, and therefore, of course, there's a huge focus on the international level. Of course, the more professional we get, the more gaming houses and training facilities, so physical presence is relevant. But in general, esports is virtual and international. So the big question arises, is German law even applicable? Or which legal system is applicable? And in Europe, in order to answer that, we'll have the Rome I regulation, EU law, which states that for contracts of civil law, for example, an employment contract, if there's an international context, which we have, I just stated that, you can actually choose the legal system you want to apply in the situation. But you cannot do that without any borders. For example, some of you might be confined to just say, oh, I'm not an expert on North Korean labor law, but probably the protection standards aren't that high there. So I choose the employment law of North Korea. Or the employment law of Japan, because sports and esports players are not considered employees in Japan. You cannot do that. There are, of course, restrictions. Mandatory law cannot be circumvented. This can even be interesting in Europe. For example, the French legal system, the French employment law is really interesting. They have a quite high standard. There's this case, it's called boss napping, combination between boss and kidnapping, and I guess the rest you can imagine for yourself. So this might be even interesting internally in regards to Europe. If there's no choice of law or mandatory law that got circumvented, Article 8, paragraph 2 of the Rome I regulation will tell us what to do. The law is applicable from the state in which or from which the employee habitually carries out his work. This could be the location of the server, this could be the location of where the work result is received from, or from where the instructions are issued, but it is the location where the device is operated. So the answer to the question is German law applicable? Yes, when you choose German law, or when you haven't chosen a legal system and the input device is operated in Germany or from Germany, and sometimes when German labor law is circumvented, even though you've chosen a different legal system. Third question, and the last, the big one, when is a player considered to be an employee in Germany? And there are actually two scenarios here that are important. First of all, the contract explicitly states that it is an employment contract. And secondly, the contract does not explicitly state that it's an employment contract. The first one is pretty easy, and a good example would be the whole LEC Riot Games situation again, because Riot Games actually requires the esports organizations that take part in the LEC to employ their players. So if they're not employed, they're not eligible to play. And if that's the case, all of the esports organizations, of course, will employ them with employment contracts. And even if the person would actually be an independent contractor, we get to that in a second, you can upgrade him to an employee. So you can upgrade an independent contractor into the employee status. On the other hand, if the contract does not explicitly state that's an employment contract, we have to check. We have to test the contract. We have to test the situation, whether the player is an employee or an independent contractor. And this is really important. For example, an example would be the Virtual Bundesliga, the FIFA competition of the German Football League, because the legal documents state that you need a contractual relationship, but they do not require an employment contractual relationship. And why is this important? It's important because 611a BGB, which is the German civil code, states if the actual execution of the contractual relationship shows that it is an employment relationship, the wording in the contract is irrelevant. So you can upgrade an independent contractor into employee status with all of the protection, but you cannot downgrade an employee to the independent contractor level. So we now have two sub-questions. First of all, can esports be qualified as work? Because for most of the people, it's a hobby. Some may play on an amateur level, but it's actually a leisure activity. And in order to answer that, we can look at what the German Federal Labor Corps said in order to qualify traditional sports as work. They said sporting activity is not considered work as long as it is performed as a purpose in itself, leisure activity. It can, however, be considered work if one, the athlete, earns at least partially a living by exploiting his or her athletic abilities, and two, and at the same time promote the economic interests of the person entitled to the service, so the employer. In addition to these requirements, sports is considered work if, in addition, 611a of the German Civil Code, the requirements of this law are fulfilled. We'll get to that in a second. Right now, there's no decision of the German Federal Labor Court whether this would be applicable in the esports situation, but there's unanimous, everyone is really sure about that, because the basis, the problem of esports and sports being, for most of the people, leisure activities, it's comparable. So I don't know anyone actually who says that this situation would not be comparable. So probably this will work the same way. So the big question is now, what's about the 611a German civil code? So this is German, don't worry, I got it translated for you. There are four major requirements in order to be an employee. The first three I just want to mention real quick because they're not that important. I want to highlight the fourth one because this is where we really distinguish the independent contractor from an employee. So first of all, private contract. This may sound trivial, but it's actually not. When we're outside of esports, civil servants in Germany are not employees. They have special legal situation, special laws. In the EU, for example, a civil servant would be an employee, but the situation not really that interesting in esports. Work or effort for another person. Here we distinguish pure employees from shareholders. in professional esports players most of the times are not shareholders of the esports organization they're playing for. But there are some cases. For example, the most famous League of Legends player, Faker, for example, is a shareholder of T1 since last year, if I remember correctly. And thirdly, you need payment, even though payment is not a requirement. It's actually the consequence of an employment contract. So yeah, if you get more money out of it than just the expense allowance, it's quite a big indication that you're actually an employee. Perfect. Now let's focus on the fourth and most important part. Work performed under the instructions of another person in personal dependence. This is quite hard to translate from German, so just scrap that part. It's not that important. Here we have the distinction between employees on the one hand and independent contractors on the other hand. So how do we get to the result whether the person is an employee or not? The question is always, does an overall consideration of all legally relevant facts show that the working person has committed him or herself to following the instructions of another person? So it's all about instructions. We got to scan through the execution of the contractual relationship in order to find out whether we pass a certain threshold. Where this threshold exactly lies, nobody knows. But if you're a lawyer in employment law, you have quite a good feeling about it. What I'm going to show you now is the same. It's kind of the same everywhere in Europe, but also in Japan, even in Russia. The right to issue instructions may concern what to do, how, when, and where to do it. So when we try to distinguish employees from independent contractors, the first one doesn't really help that much because, of course, you also tell an independent contractor what his job is. So the focus lies more on the how, when, and where. Always an individual decision, but we have a problem in esports because esports is digital work. And you see when we go back there, how, when, where, these are all problematic in a sense of digital work. The player could work and theoretically from anywhere, train wherever you want to train, and of course, how to. He's the professional. This is why the esports organization employed the person, at least in the game. So the consequence is that 611A of the German Civil Code is not ideal for the digital work. But, and this is important, in almost all cases, a professional player will qualify as an employee, although the German Federal Labor Court has not decided on that yet. But there are a lot of indications that this will be the case. First of all, outside of playing the video game, so training, content creation, how to behave when you're on a physical event, there are actually a lot of instructions. The more professional the team, the more specific are all the instructions, the plans, when it comes to time or place. There's always at least one instruction regarding location. Be at a place where you can play at the highest level, of course. And I would even say, more importantly, it's possible to target the virtual work location, so the in-game lobby. And this, of course, is really important for the employer, that the employee is in an in-game lobby at the right time. So these are just some of the indications which lead us and everyone else I know to the conclusion that in almost all cases, a professional player is an employee under German law. There's one last thing I want to mention. There's a discussion whether this is just for team players because they get a lot of instructions. They need to coordinate everything with each other, for example, versus solo players. In my opinion, solo players have also a really high chance of being qualified as employees because you do not compare the instruction level from team players with solo players. You compare a comparable person. So a solo player, is he an employee or an independent contractor? And just because there are less instructions in general, this does not mean it's not possible for him or her to be an employee. So, as a summary, and I feel like I'm in time, the actual execution of the contractual relationship shows that is an employment relationship. If you try to deprive an employee in Germany of his rights, of his special legal protection, you will suffer serious consequences. It's not always easy in Germany, especially when we talk about digital workers, whether someone is an employee or not. The court will, and I will promise you that, come to the right conclusion. And for esports athletes, this generally means employees. So this is important not only because of the serious consequences, but of course you have to really keep an eye on all the requirements in labor law and employment law, fixed term contracts, terminations, paid leave. I already mentioned a few of them. So really important topic, and hopefully we'll get the chance over the next months and the next sessions to dive deeper into the employment law in regards to esports. Perfect. Thanks so much for your attention and your time, and I'm really looking forward to your questions.